Good afternoon and welcome to our newsroom special coverage of the Court of Appeal's decision in the Vibes cartel matter. With me is our legal analyst, Dion Jackson-Miller. Dion, welcome. We're live here on YouTube, on TVJ's YouTube page, Facebook, Instagram. Later we'll be joined by our colleagues on JNN and Radio Jamaica. Today we'll hear whether the entertainer Vibes Cartel and his co-accused will face a retrial for the murder of Clive Lizard Williams or be set free. On March 14, the Privy Council in London, Jamaica's final court of appeal, overturned the convictions of Cartel, whose real name is Adidja Palmer, and co-accused Shawn Campbell, Kahira Jones and Andre St. John. It ruled that the Court of Appeal of Jamaica should decide whether there should be a retrial. Now, while we await the Court of Appeal's ruling, how did we get here? Giovanni Dennis has this timeline of events.
Firstly, who is Vibes Cartel?
I am Adidja Palmer, dancehall artist / hero, businessman, proud father of 7 children. I'm counting.
So how did he end up in prison? And Commissioner of Police, Elon Powell.
The investigations surround murders.
This now derelict property on Swallowfield Avenue in Havendale, St. Andrew, is the last place where Clive Lizard Williams was seen alive on August 16, 2011. Mr. Williams was summoned here along with the prosecution's key eyewitness Lamar Chow to account for 2 missing guns by entertainer Vibes Cartel. Mr. Williams, Mr. Dix, Kahira outside the room. He said he was cornered by Vibes Cartel and Shawn Campbell and brought back inside. He said when he went back inside, he saw Williams motionless on the ground. He then made a run for it, jumping over the wall. Clive Lizard Williams has not been seen or heard from since that fateful Tuesday night, nearly 4,600 days ago.
The murder trial was the longest in Jamaican history, lasting from November 18, 2013 to March 13, 2014. TVJ's Dara Smith.
Now, after 65 days, 30 witnesses, 24 for the prosecution, 6 for the defense, 5 unsworn statements, closing submissions from both sides, and some 5 days of summation from Judge Justice Lennox Campbell. And after 2 hours of deliberation, the jurors today arrived at a decision. 10-1, Vibes Cartel, Adidja Vibes Cartel Palmer, guilty. Shawn Campbell, guilty. Kahira Jones, guilty. Andre St. John, guilty. And then you have Shane Williams. He was found not guilty.
The men were sentenced on April 3 that year to life in prison. Cartel, 35 years before being eligible for parole.
I'm not look for 30 or 15 for you, oh God, man, have mercy upon you.
You look for the minimum sentence of 15 or 10 years.
Cartel no deserve 35 years. Cartel deserve 15 years because Cartel not kill nobody.
Since his exactly 6 years after his 2014 conviction, on April 3, 2020, a 3-member panel of judges in the Jamaican Court of Appeal reaffirmed Cartel's conviction. On April 17, 2020, the Court of Appeal reduced Cartel's parole eligibility to 32 years and 6 months, citing the presiding judge's failure to consider the time the DJ had spent in jail while awaiting trial in 2014. Fast forward to February 14, 2024, a fast-tracked hearing before the Privy Council. One of the defense's concern, the case should have been dismissed or restarted because of a corrupt juror, Livingston Kane, who attempted to bribe other jurors to return a not guilty verdict. Exactly a month later, March 14, the Privy Council quashed the men's convictions. Giovanni Dennis for Television Jamaica.
Now, Dion, as we heard in the timeline, what are some of the issues that you think the judges would be weighing in coming to our decision today?
Well, the factors that the courts look at in deciding whether them are set out in cases over the years. So they're going to look at the strength, and we can bring it to the prosecution's case. They're also going to be looking at the seriousness of the offense, the time and expense that a new trial would take, the length of time from the offence as well as when a retrial would take place and the evidence available for a new trial as well as public impact. They also said that these factors aren't exhaustive, meaning other issues can be considered depending on the case. And I can tell you certainly one of the issues that's going to be considered in this case is the impact of publicity.
All right, Dion, we're going to go straight to the audio feed from the court.
That was remitted from the Privy Council to this court. At the end of the submissions, we reserved our judgment, and the court is now ready with its decision. The decision of the court is unanimous, and we have a judgment in writing, which is still subject to editing in any event because we were trying to make the deadline. What we have done is to extract a summary of our reasons for the decision with the promise to release the full judgment as soon as possible. So what the court has today is a summary which is in writing and will be released. And we have a disclaimer. This summary is provided for the sole purpose of assisting members of the public with understanding the Court of Appeal's decision in this matter. It does not form part of the reasons for the court's decision and should not be used as a substitute for the judgment of the court, which is the only authoritative record of the court's reasons. The full judgment of the court will be made available to counsel and through the court's website at www.courtofappeal.gov.j. On 13th March 2024, the appellants, Shawn Campbell, also known as Shawn Storm, Adidja Palmer, also known as Vibes Cartel, and Kahira Jones and Andre St. John, also known as Madsus, were convicted of the murder of Clive Williams, also known as Lizard. The appellants appealed their convictions to the Court of Appeal and then to His Majesty in Council. On 14th March 2024, 10 years and 1 day after they were convicted in the Supreme Court, the Judicial Committee of the Privy Council recommended that the appellants' convictions be quashed. The Privy Council remitted to this court for determination the question of whether the appellants should be ordered to stand a new trial. Over 6 days, the court comprising Judges of Appeal MacDonald Bishop, P. Williams, and D. Fraser heard arguments by counsel for the appellants on the Crown on that question. The court has considered counsel's written and oral arguments, as well as the authorities and evidence filed by both sides, and has arrived at a unanimous decision. For a fulsome appreciation of the question remitted to this court for determination, and the court's resolution of the issues and sub-issues raised by the parties relative to that question, an abbreviated summary of the background is provided. The allegations in the court below were that the deceased and Lamar Chow, the prosecution's sole eyewitness, had been given 2 unlicensed firearms belonging to Palmer for safekeeping. The appellant Palmer gave Lamar Chow and the deceased a deadline of 8:00 p.m. on 14th August 2011 to return them, with which they failed to comply. As a consequence, Lamar Chow and the deceased were summoned by the appellant Campbell to the appellant Palmer's house at Swallowfield Avenue, Havendale, which we call the Swallowfield premises. They went there by taxi on 16th August 2011, accompanied by Campbell, and on arrival were met by the appellants Palmer, Jones, and St. John. The appellant Palmer asked what plans Lamar Chow and the deceased had for replacing the firearms, to which the deceased replied that he would replace them. They were then both attacked, after which Chow saw the deceased lying motionless on the ground, with the appellant Jones bending over him. Lamar Chow escaped, but the deceased was never seen again, and calls to his mobile phone went unanswered. A team of police officers went to the Swallowfield premises to investigate the alleged homicide. They noticed that the house smelled of disinfectant. When the police returned to the premises on a subsequent visit, they found that the entire interior of the house had been destroyed by a fire. On a further police visit, it was discovered that the rear of the house had been demolished. The police dug at the premises but did not find anything of significance to their investigations. The appellants were taken into custody on 30th September 2011 and subsequently charged for the deceased's murder. They have been detained ever since. The appellants were tried in the Home Circuit Court before Justice Campbell, the trial judge, sitting with a jury. The trial lasted 64 days. During the course of the trial, there were 3 incidents involving the jurors. The first and second incidents are not relevant to these proceedings and will therefore not be discussed. It suffices to state that after the second incident, the jury panel was reduced to 11 members. The third jury incident came to light on 13 March 2014, the last day of the trial judge's summing up of the case to the jury. Following the report of possible jury misconduct, the trial judge convened a hearing in chambers and informed counsel on both sides that he had been made aware that a juror, who we call Juror X, attempted to bribe another member of the jury with an offer of $500,000 to decide the case in a particular way. The trial judge and counsel on both sides questioned the forewoman of the jury in chambers. The forewoman informed them that Juror X had spoken to all the jurors and encouraged them to free the appellants without regard to the evidence. There was no evidence to connect any of the appellants with the activities of Juror X. Faced with the possibility of having to abort the trial judge heard submissions from the Director of Public Prosecutions, the DPP, and Defense Counsel. Despite Defense Counsel's resistance, the trial judge decided to continue with the summing up and handed the case over to the jury that evening. The jury deliberated for over 3 hours and by a majority of 10-1, convicted the appellants of the deceased's murder on the same day. The appellants were each sentenced by the trial judge to imprisonment for life at hard labor, with the stipulation that the appellants Campbell and Jones should serve a minimum of 25 years in prison before becoming eligible for parole, and the appellants Palmer and St. John should serve a minimum of 35 and 30 years, respectively. The appellants were unsuccessful in their appeal to this court and appealed to the Privy Council. The Privy Council allowed the appellants' appeal and quashed their convictions on the basis that the trial judge's treatment of the third incident of jury misconduct was a material irregularity in the course of the trial, giving rise to a miscarriage of justice. In the Privy Council's view, the trial judge should have done more to investigate the third incident of jury misconduct and not rely solely on the forewoman's account. Furthermore, allowing Juror X to continue to serve on the jury was fatal to the safety of the convictions and was an infringement of the appellant's fundamental right to a fair hearing by an independent and impartial court under Section 16 of the Constitution of Jamaica. Lastly, the fact that the prosecution was prepared to waive the irregularities in the trial did not absolve the trial judge of his responsibility to ensure a fair trial. In all the circumstances, the trial judge ought to have discharged the jury and ended the trial in order to protect the integrity of the system of trial by jury. He ordered to face a new trial, or whether judgments and verdicts of acquittal should be entered. The court starts with the Constitution, which provides that upon conviction, a person should not be tried for a second time unless a court of superior jurisdiction, which is the appellate court, orders that there be a retrial. The Constitution did not set out the circumstances in which the court should order a retrial. It is to case law that the court looks to determine trial. The principles governing the question of a new trial, which was set out more Privy Council in the case of Reid against the Queen. We will not state 20 cases since Reid, and we have an amalgamated list of those factors. There are 12 factors that the court has considered. The seriousness and prevalence of the offense, that's one. 2, the strength of the prosecution's case. 3, the availability of the prosecution's witnesses and exhibits be facilitated within a reasonable time. 6, the time. 7, the ordeal to be faced by the appellants if a new trial is ordered. Publicity on the fairness of a new trial, if ordered. 9, 11, potential legislative changes in the sentence for murder. 12, the possibility of prejudice arising from the mandatory minimum sentence and minimum term before eligibility for parole. We have considered all the factors governing the court's determination of whether a new trial should be ordered, and have given due regard to all the material, submissions, and evidence presented by the appellants and the Crown. We commence by stating that the egregious nature and seriousness of the offense in this case is beyond argument. So too is the prevalence of the offense of murder in Jamaica. We make a barefaced defiance of law and order involving allegation recovered, or should we say an alleged killing in which the body of the deceased has not been recovered, and interference with the role of the police. The court is therefore satisfied that the nature, seriousness, and prevalence of the alleged offense in this case, that there are several equally powerful factors which, when combined, militate against ordering a new trial. In summary, these factors are the insufficient and inadequate account by the prosecution for the availability of its witnesses and trial exhibits, are now unavailable or cannot be accounted for. 3, they are 64 days and utilize a significant share of the court and the appellant's resources. Therefore, the time, financial costs, expense, and impact on the court's resources, as well as trial, we find that this is significant and it militates a medical effect that a new trial would likely have on the appellants who have already spent 13 years in custody with problems relating to the appellant Palmer, which came through medical reports that stand unchallenged by the Crown and therefore speak to declining health in the penal institution. The court looks at the lapse of time, estimation be at least 15 years. We find that to be inordinate. 6, the unjustifiable interference with the appellant's constitutional rights to a fair Section 16 of the Constitution of Jamaica and the potential for that breach or interference, we should say continuing, if a new trial is ordered. We look at the potential prejudice to at least 2 more eligibility for parole than that which was originally imposed upon them after their first trial due to the operation of the statutory mandatory minimum for the offense of murder. The court looks at other factors which it did not see swinging the pendulum either way. Publicity did not assist the appellants. We find that pre-trial publicity is such that you would have to prove that it is impossible to obtain a fair trial. And that question is one for the issue of pre-trial publicity is if the mechanisms have to be employed as the Crown had argued, that would add to the delay of the proceedings. As we have said, we have looked at all the other factors, but we find by now the countervailing, the weight is against a new trial. Our judgment will echo what the court has done. Having regard to all the considerations the court has taken into account, we conclude that the interests of justice do not require a new trial to be ordered for the appellants, and we therefore make the following order. Judgments and verdicts of acquittal record. Thank our judicial clerks, Mr. George Lennon and Ms. Shaniel Hunter. Had it not been for them, their assistants would not have been able to make the deadline given the workload of the court and the various things that we had to do over the past. It leaves us to thank counsel on both sides for your spirited, maybe sometimes combative arguments, but we have learned tremendously from both sides, and we hope that the judgment will show that we appreciated the scholarship and appreciated the issues for resolution. So that is it. The appellants are freed.
Welcome back. So Justice Marva MacDonald Bishop, the President of the Court of Appeal, delivering the Court of Appeal's decision, essentially freeing Vybz Kartel, Shawn Campbell, Kahira Jones and Andre.
Watching who is not clear. The court has ordered that the 4 men should be freed, that verdicts of acquittal should be entered, which means they are going to be free. There's not going to be a retrial. So let's just say that up front. Now, the strongest to be the fact that this was alleged to have been an extremely heinous murder, gruesome circumstances, and in a high crime environment like Jamaica, there's always going to be an argument to be made that the seriousness of the offense.
Bareface she used, yes.
Bareface, and she said bears a hallmark of a deliberate attack on and a barefaced defense on law and order. So she made that point. About the first thing she mentioned was the issue of the availability of evidence and the exhibits.
Exhibits, yes.
So what happened was that during the hearing into whether or not there should be a retrial, one of the attorneys representing the men, John Clark, raised the point that the exhibits that had been available in the first trial, that they needed to be, that had been produced or that had been brought in at the first trial, but he said only 14 of those had been verified as being available for retrial. He said among the ones that had not been verified were some of the most important. The DVD that contained the video that was alleged to have been of the murder, as well as the DVD that contained the voice notes that I know a lot of people heard about, the voice notes.
Which were circulated on WhatsApp and so on, yes.
And that's a lot of allegations. The judge, and obviously that's going to be huge because those are critical aspects of the evidence. In addition, the defense also said that some of the, why can't they be found? Did they disappear? Did somebody thief them? What happened?
Yeah, I mean, the chain of custody.
And then the president also mentioned the issue of witnesses. And again, she had been asking about that during the retrial hearing. She had indicated assertion that their witnesses were available for a retrial. You know, she was saying she wanted to see, for instance, my words, not hers. I called Milton. Milton says, yes, he'll come. I called Dion. Dion says, yes, he'll come. Yes, she'll come. And she was saying she wasn't getting that kind of detail in terms of the availability of the witnesses. And you saw her mention that as an issue, and that clearly is going to be an issue if you're talking about a retrial where you're depending on a sole eyewitness and all these very...
It would be now 15 years.
That was based on the fact that the men have been in custody now for nearly 13 years, and they were trying to figure out how long it would likely be before a retrial. So they had asked the Supreme Court, you know, the matters that we have sent to you for retrial, what has happened to them? And what they heard was that 2 matters had been sent, one in 2022, one in 2023, and neither of them, October 2022, October 2023, neither of them had yet been tried. So the Court of Appeal was saying, okay, so this perhaps will give an indication, which is why she said they're estimating probably another 2 years before you could have a retrial, which means that the men would then have been in custody for 15 years in all. And then that she was saying as well in relation to 2 of the men, because of a change in the law now has a mandatory minimum. I have to check the exact amount. Sorry, I should have checked that before. It's supposed to happen.
Why would that be so when the crime was committed? The law was at a particular point when the law at that time was for the mandatory minimum sentencing law wasn't in place.
I'm not sure.
No, I'm saying, why would that be a factor?
Oh, they're saying that
even though
because remember it's
committed.
going back to a retrial, so you're going to have a trial all over again. But I understand we now have our colleague Dwayne.
Dwayne Anderson is outside the Court of Appeal in Justice Square. Dwayne, tell us what's happening there.
Thank you so much, Milton. Well, as you can imagine, for a matter that has been going on for about 14 years, not a lot of people were aware that there was a monumental development in the case today. So really a small crowd gathered here in Justice Square in downtown Kingston. But when news is fans, she's here almost every day. There's a matter involving Vybz Kartel, and she's literally cried tears when things have not gone his way in this matter. She now joins me. Sandy, your immediate reaction to Vybz Kartel being freed by the court?
Yeah, I'm not lie, I'm glad, I'm happy, I'm glad the boss free time come. A long time now them for free the boss. I'm a thank the court system. I'm a glad Kartel free today. Big up yourself, Kartel. My foot sick and me have to come out, come represent for you to the street. Look a while to all me boss free to the time come. Over 18 years or 18 years, no man time come today. My talk it and it happen. I know the boss did I go free today. Free. I come with good luck, I not come with bad luck. I know say the artist did I go free. Anything I say it go. That. Anything I say, did have to come to the street. Anybody who God bless, no man curse, right?
That you're not just here by yourself, but you're also here with your mommy. What does Kartel mean to you and your mother, really, why you all came here from Dwayne Park?
Well, I nah lie, you know, my mother and Kartel born January, and my mother always say she and the boss born January, so you don't know. My day who my mother say, you know, say I feel like mother go down with the court there today. I say, come mommy, oh you mean we are going to represent straight, because the boss are come today and see that happen.
Final question for you, Sandy. What would be your advice to your favorite entertainer for the first thing he's supposed to do when he comes out on the road?
Well, family time, build up them time, the back, and you don't know, just be safe and keep yourself out of trouble. And you know what, them way they keep prayed up, same way, you know, big up yourself. Well, you don't know party after that and the party thing a lock. You don't know a right show, anything anywhere.
Now, as I mentioned, a small crowd really gathered here in downtown Kingston this morning, meaning it was a relatively incident-free, well, so far for the security personnel who took out all the stops to ensure that, security was beefed up here in Justice Square. Behind me, persons who are looking on can see that several police officers and proceed peacefully here today, and things have been going peacefully. It's really a hot day, and maybe that is part of the reason not a lot of people came out. A lot of the persons who said that they came here to see what was happening, they did allude to the heat, and persons don't really want to come out here and risk getting a heat stroke just for a matter that doesn't necessarily involve them personally. Now, I'll be here monitoring what happened as it relates to outside the court, and I'll be sure to share it with you, Milton.
Dwayne Anderson, thank you. Dwayne Anderson reporting live from Justice Square. Dion, Justice McDonald Bishop also raised the issue of the psychological who has been gravely ill with, I think it's a grave disease.
The defense had brought medical reports and affidavits from doctors attesting to Cartel in particular, his physical deterioration, his mental deterioration as well was a factor. And the other side has medical evidence, medical evidence coming from medical doctors, from physicians. Why would you not also have an affidavit from a prison doctor if it is that you're trying to challenge what they're saying? And, why not meet like with like? What are we supposed to do really with medical evidence, quote unquote, from a prison? So wasn't counted, and they went into a great deal of detail in terms of, as you mentioned, the issue not just of Graves' disease. We were told psychological impact. We heard that in respect of all the men, but this emphasis in terms of mental and physical deterioration, I think, was most marked and most pronounced and most argued in the situation with Vibes Cartel.
We had heard legal experts had said that the prosecution's case presented at the Court of Appeal was pretty weak, and many persons were surprised at that they didn't seem to prepare a very strong case.
Well, there are a number of things that, when you're talking about pivotal evidence, in relation to the issue, for instance, of the impact, that issue that the Justice McDonald Bishop mentioned about the ordeal on the men.
Yes.
And the prosecution now was trying to make the case that, and at that point, when the acting DPP started to go into that a little bit more, she was stopped by the judge who said, hold on, there's no affidavit evidence in front of us on that point. So apparently there hadn't been any affidavit evidence filed from relatives of Lizard Williams, for instance, to say what they had been going through and what it is that this kind of situation, the murder, the reports of the murder, the whole situation, the impact it had on them. Lawyer that should have been in affidavit evidence. So that I was a bit surprised at as well.
And there seemed to be years before a possible trial.
The Supreme Court had said, to be fair, that they can't fast-track cases, but one of the questions that Justice McDonald Bishop was asking consistently throughout the hearing was, what makes this case so special? She was pointing out, for instance, that one of the cases that was still awaiting retrial was a case in which a businessman was alleged to have killed the mother of his child in gruesome circumstances. But then you look at this other case awaiting retrial, what's the basis on which you're going to say, let's jump the cartel case to the front of the queue before those other matters that are also extremely important, and also especially given the fact that 64 days, one of the longest trials in Jamaican history, and the defense lawyers had indicated at the retrial hearing that there were some motions they intended to make, there were some challenges they intended to make that would likely mean that a retrial would be even longer than the first trial. So you have to the front of the queue would be pushed even back. More of the court's resources have to be devoted to this.
I was also struck that she mentioned in some detail, one, that the trial would be complex, but it will take a lot of court time and resources. I would have thought in the pursuit of justice, it didn't matter. Those factors wouldn't really matter.
Well, I'm looking forward to reading the judgment in terms of how it is there for.
Pause there for a minute, because we're now joined by Anthony Lugg, who is in Gaza City. That's where Cartel is from, in Waterford in Portmore, St. Catherine. Anthony, good afternoon.
Thank you so So jubilation here in Waterford in Portmore St. Catherine with pure excitement. We're under the watchful eyes of the security forces. However, as news just came out of the ruling from the afternoon.
Well, everybody's similar reaction. And it's not just this afternoon. It's from the beginning and now it's the end. And the end is the best. And out of the worst is the best, and that we get today.
All right. Gavin, earlier I was speaking to you. You said to me it's been some long 13 years. You know, what has it been like for you, and how do you move forward now, hearing that Adidja Palmer is free?
Well, but he's like a brother when he's here and when I'm with him finished.
All right. Happiness. I'm hearing about party later. Talk to me about that.
No, I didn't hear about the party.
All right. Thank you very much. Well, Gavin said he doesn't know about any party, but I can tell you scores of people are telling us that a lot of people are at work now.
Thank you. And Dion, just for our viewers, what happens next in terms of the men? They'll be free today. Is there anything else that needs to be done?
Well, there's some paperwork that's going to have to be done, so it depends on how quickly they get through that as to exactly when they'll walk free. I should say, Milton, that I know there are going to be concerns about the decision. I've already heard some of them. People are going to be...
Hang on. I'm told that there's an incident outside the court in Justice Square. You're seeing live pictures there. If we could hear the sound there of the square right there on King Street, but it seems that persons having heard the ruling have come out. But Dion, you're saying? Mm-hmm.
Well, I should just say the men are not in court. It's not like a trial where the men would be in the dock and the verdict would be handed down. The appellate process doesn't require the appellants themselves to be in court.
Right.
So
penal facility.
Correct.
Mm-hmm.
Now, in addition, I was saying there are going to be concerns about this decision. There are people who are going to think that the decision is wrong, and that's perfectly legitimate. Courts aren't sacrosanct. You're allowed to criticize them. I would just remind people, though, that the men have spent 13 years in custody. So it's not that, there's absolutely nothing that has happened here. So we are awaiting the summation, the summary that the president of the Court of Appeal indicated would be getting hopefully now or in a short time, as well as the written judgment to really delve into it and to be able to say whether or not we do agree with the way in which they weighted it.
Right. And we're standing by to get an interview with the attorney for Vybz Kartel, Mr. Isaac Buchanan, but we're just awaiting him exiting the court. Right, so he has been surrounded by the crowd, so we're waiting on to be able to get closer to Isaac Buchanan so we can bring that interview to you.
I should tell you that one of the points that was made at the hearing, the retrial court, the length of the court matter on them, and they were arguing that the men were now, in fact, financially, what should I say? Stressed.
Or worse off, yes.
There you go. As a result of, because legal fees are expensive. And one of the things that they were saying is that, basically they've had to go to legal aid to get representation at this particular stage. And, there was a little bit of a moment there in court. But just a reminder that Isaac Buchanan, in fact, had gone to the Court of Appeal. They'll be getting a whole lot of props for this. John Clark as well, I can tell you, who argued a lot of the matter as well at the Court of Appeal retrial hearing. Also, very, very, very significant submissions made by him.
He's really like a hero to the crowd. I'm told that Dwayne Anderson has Isaac Buchanan now. Dwayne, go ahead. It's really would be a little challenging.
Well, as you can imagine, the crowd has grown substantially in the last 5 minutes. So much so that defense for Vybz Kartel, he was flocked by people to a hero's welcome. Trust me when I tell you, I had to almost wrestle him out of the crowd to get this interview live. Isaac, you're successful. The justice system worked today?
The justice system works. The starting point is always God. God and time, and we saw it happen today.
What was the clincher for you? What was the clincher for you? What decided it?
The deciding factor, as the court made it clear, it was the health of Mr. Palmer, the absence of the witnesses, the absence of the exhibits, the absence of our most significant witness.
as well as when you put it all together, the length of time, the breach of the constitutional rights, all of it overwhelmed, and the delay was what caused it to be the judgment of acquittal entered.
Well, let's delve into a couple of those. Tell us about Vybz Kartel's health right now.
His release. Our expectation is that he will be released today.
How bad is his condition?
No, well, you heard a month ago his heart function was instantly.
And let's talk about now some of the exhibits missing and some of the crucial material needed missing. Is that an indictment on the justice system?
No, I'm not putting it. We are not indicting the justice system. We can't have our cake and eat it too. The justice system works. And I can tell you, under the guidance of Justice Sykes and now our Madam President, Jamaica has a father and a mother going into emancipation.
You've taken a few losses in this matter, over the build-up, but you've basically won the war, and the people showed you that love just now.
In this case alone, Mr. Chevalier was my student at the University of the West Indies. This case takes so long, he became an attorney and he's on the matter and he did very great work. Mr. Clark, Mr. LaBeach, Mr. Tom Tavares Simpson, Bert Samuels, Miss Valerie Nita Robinson, Mr. Help me with all of the names. Listen, there are so much, Michael Lorne, Pierre Rogers, every attorney that was a part of this matter did the work. The attorneys in the UK, we all worked together to ensure that justice was served. We have a justice system where innocent men are in prison, and we have to start an innocent project to make sure that we review these cases and that we give effect to the Constitution. That is what's on my mind right now.
When they say that the men are freed, can we expect to see them out this evening, tomorrow morning? When?
Certainly, it should be done by today, no matter what happens. And if they do, the prison is to do all that they can, and they usually do. Mr. Campbell, once he gets the order,
but obviously his fans would want to. They've not been able to speak to him and hear from him. Any plans for a party anytime soon, or what is his health like that will make it possible?
I don't want to get myself in any problems, but the medical team need to be on standby, and everybody need to see them. That's all I know.
All right, thank you so much, Mr. Chevera. You can have a quick word with us. Just come around here a little bit. Yes, because we're live and we want Jamaica to be able to see the persons who participated in the case. Tell us about your involvement and what you believe was really the clincher.
Certainly, it was a team effort. We started from the beginning and realized that the men needed individual attention. So that is why Mr. Buchanan and Senior on the team, we decided that we're going to separate the team. Certainly, the clincher for us was the health situation of Mr. Palmer and also the prolonged delay that took place in this matter. And certainly, this is not a one-hour circumstance, and other young men in Jamaica can get the benefit of swift justice as these appellants were awarded.
Well, thank you so much for joining us on Television Jamaica, and congratulations to you and your team. Take care. Good. Well, as you can imagine, the news travels pretty fast, and what was really a very small crowd about 30 minutes ago has exploded to about, just by my estimate, about 1,000 people. It's like they popped out of the ground as news surfaced that, listen, Vybz Kartel will be freed. And as his defense out of prison this evening. So we'll be monitoring that and see what happens. It's back to you, Milton.
Okay, Dwayne Anderson reporting live from Justice Square. Dion, what struck you from what Isat said about from his perspective about today's...
So he doesn't have any reason to raise questions about what happened. But when he said the justice system works, again, I have to point to some of the really egregious things that happened in this case, to the treatment of the exhibits at trial, the fact that a cell phone belonging to Kartel that was in the custody of the police was used to make calls while in police custody, and to the fact that, as I'm saying, some of these critical exhibits were not verified as available for retrial, and we need an explanation from whether the police, the prosecution, but there needs to be an explanation to the people of Jamaica as to what happened in this case. Surely in such a case that would have been under the microscope, you would have expected every I to be dotted, every T to be crossed, and for this kind of blatant carelessness to put it at...
Some of that carelessness in quotation marks from the trial, and to come now at the end stage when you're presenting the case before the Court of Appeal, not to, have some basic things lined up.
Yeah. Isaac was making the point that he's hoping it can happen today because, and indeed, in a matter like this, I would expect them to be walking down the judgment, actually waiting for it to be finally prepared at the Court of Appeal and then actually carried down to the prison system. And once they get that order from the court, then they would be able to release them. So we'll see what happens there.
Tell me, he did say that his heart was now 32%, so he seems to have had some deterioration because I think he had said it was about 50%.
He had said 50% worse than last year. So I don't know where he is now, but I mean, clearly the court was convinced by the medical evidence and the medical reports that were submitted. He
also mentioned that I'm not sure if he'll be championing that Jamaica needs an innocence project, which is, a lot of in the United States, our students have gone through and looked back at the case. They've found material evidence which obviously, or in many cases, lead to acquittal after, 10, 20, even 30 years in prison.
Yeah, it's something I follow in the United States. I think it's an absolutely wonderful project. But and it's interesting to hear Isaac raise it. I've never heard it raised in the Jamaican context before. The Innocent Project, though, only takes cases that can be proven by virtue of DNA. Do we preserve DNA? How well do we preserve DNA? Can you, find cartel case exhibit 1? Can you find the DNA? I don't know if that's something he's going to be pursuing. We, of course, do have legal aid here, but in terms of the kind of process he's speaking about, where you actually carry out investigation into a case to determine whether or not there had been an incorrect finding of guilt, personally, something I would certainly be interested to see.
Indeed. And he also mentioned the delay, Isaac, that is, as one. He said health, the absence of witnesses and exhibit, and the delay. Those are the three main points that he cited.
I should have mentioned as well, when I was talking about the issue of availability of witnesses and the court's concern about whether the prosecution witnesses would be available, one of the defense's chief witness has actually died. And that was their handwriting expert, who has that as a significant concern as to how they would be able to meet a trial, to respond in a trial if indeed a retrial is ordered.
So do you think the DPP's office, the acting DPP, ought to come and address the nation, speak in a press conference or stuff about some of the issues which were thrown up by this case? That would be...
Well, I'm in media, so I'd love to see a press conference or something of that nature. Whatever the indication I've got is that we're unlikely to see something of that nature, but that we are likely to see a response coming out from the office, and I think we'll
in a statement, perhaps.
But as I said, some of these questions that I've been raising do need to be answered, so we'll look to see what it is the office says.
And of course, folks, we'll have more on the freeing of Vybz Kartel and the three others in Primetime News and Beyond the Headlines. Dion will be on Primetime News giving us some more analysis, and I'm not sure if we'll get the written judgment by then. And she, of course, will be on Radio Jamaica on Beyond the Headlines, where we'll be delving more into the case and speaking, of course, to some of the attorneys and possibly someone from at 8:30 on TVJ and onespotmedia.com. We'll have a 1 full hour to go through the case, and she'll have all the attorneys and legal experts who will be there to break it down for our viewers later. Dion, your final thoughts?
I think this case has been a really significant one for the justice system. It's thrown up a number of issues. I've been speaking about the issue of the exhibits and how that has been treated. This issue of the juror misconduct, though, has also a significant loophole in our legal system, because if it's left as is, if we don't correct this, what it means is that anybody can go and bribe a juror, and then the case is going to have to be going to have to be thrown out. You're going to have the trial end and a new trial start. Right. And we did get an indication at the Privy Council, for instance, their suggestion as to how that could be dealt with his legislative amendment to say that if a jury has to be discharged, then the case can continue with a judge alone. Currently, in our system, if you discharge a jury, the case has to end. And I've said it before, I'm going to say it again. I am surprised that Parliament has not already acted to close that gap that currently exists, and I think that needs to be one of our first priorities right now.
Any other lessons you think we can take away from this case?
I want to see what the Court of Appeal said about publicity, because a lot was made about this in the retrial hearing, but we heard the President say that the arguments about publicity didn't help the appellants. They had been arguing that the publicity in the matter was so extensive, there's no way they would be able to get a fair trial, and we heard the President there assert really the current position in law, which is that once you can find a jury or some jurors who in fact can render a fair verdict, that the publicity is not going to mean that you can't have a fair trial. I think that's really important in the social media age, in the celebrity age, because otherwise, how would we be able to try celebrities?
Right. Tell me, and somebody's sent a message to me, is this the end? Final end? This case? Yeah, does the prosecution have any recourse in law?
No, man, this is a decision for a retrial. As to retrial, this is it. Nobody's going any further with this one. That's it. Moving on to the next one.
Can't remount a case or anything, no?
Well, remember, this is a verdict of acquittal that's going to be entered. Once you've been acquitted of a particular charge, you can't be tried again for the same charge, because that would be double jeopardy. Which is why it's important for that verdict of acquittal to be entered, because that then puts a full stop to the case, that draws a line under it. This one is finished.
Indeed. Well, lots of reactions we're getting in, and I know there are a lot of persons, as you said, are disappointed with this case. And of course, Cartel has a huge fan base here and abroad. I see persons from the United States, the Caribbean, messaging me about this case. So there's huge public interest in this case right from the very start. But thank you so much, Dion, for your expert analysis in this case. This has been our special report on the Court of Appeal's decision to free Vybz Kartel, and is three co-accused: Shawn Campbell, Kahira Jones, and Andre St. John.